Welcome to the Catalyst webinar and dialogue series. I'm Kendall Marlowe with the Kempe Center for the Prevention and Treatment of Child Abuse and Neglect, and thank you for joining the global community driving change in child welfare. This October, we come together again for the virtual Call to Action to Change Child Welfare Conference. This annual convening of people from across the world aims to transform child welfare and build justice and equity, all through honoring the voices of those impacted by child welfare systems. In both policy and practice, our passionately shared goal is meaningful, lasting transformation. We're here today as part of a webinar series in advance of this fall's conference. In every session of this series, we'll explore actionable initiatives that will come to life in our conference in October. We'll venture unafraid into the heart of child welfare, its history, its impact, and its future. We'll address and even challenge the core structures, policies, laws, and values that have governed our system throughout its history. And we'll ask ourselves, where must we go from here? Following each webinar, we'll then host a dialogue. Those conversations are intended to foster open, honest, and challenging debate. We invite you to join us at each webinar, as you're doing now, and then share your voice in each dialogue that follows. If you're viewing this webinar from within Attendee Hub, we encourage your questions and comments through the Q&A feature. If you're with us through Zoom, you can use the Zoom chat box function to engage. We'll have time at the end of the presentation today to address those comments and questions, and I encourage all of you, pop questions and comments into the chat if you're on Zoom, or into the Q&A feature if you're on Attendee Hub. Now, without further ado, for today's webinar session, we welcome Martin Guggenheim. Marty is one of the nation's foremost experts on children's rights and family law and has taught at the NYU School of Law since 1973. He's been an active litigator in the area of children and the law and has argued leading cases on juvenile delinquency and termination of parental rights in the U.S. Supreme Court. He's also a very well-known scholar, having published more than 50 articles and book chapters, as well as 6 books, including notably What's Wrong with Children's Rights. Marty is also currently serving as an advisor for the American Law Institute's restatement on children and the law. Marty, good to see you again. Thanks for being with us, and take it away.
Thanks so much, Kendall. And I'm happy to be here. Always happy to add my voice and contribution, especially to an audience that is interested in reimagining what we're doing in this field. I've been asked today to talk about something that is very dear to my heart, but also I do with a little bit of trepidation, because my closest allies in the field wish that I would stop talking about what I'm going to talk about today, because they have made the decision that making alliances with the children's bar in this field is the way to move forward into the future. And I'm going to make a powerful argument that the children's bar and the way our field has developed since the 1970s has contributed more to making things worse than making things better. So I unavoidably make enemies when I speak about this, and I even make my friends cringe, because they'd rather that we make nice and figure out a way to advance the goal of treating the families that are enmeshed in this system more humanely, better, with far less destructive forces than characterizes the system that we're in today. But as I advance the claim that we should have fewer children's lawyers and far more parents' lawyers, which is the critical theme of my remarks today, I want to align myself with the major theorists of the field who, like me, were largely ignored as history unfolded. But I'm thrilled to align myself with the work and writings of Joseph Goldstein, Anna Freud, and Albert Solnit, who in the 1970s, when I was a young lawyer beginning my career, really were the gurus of the field. The Kempe Center, Dr. Kemp's so-called discovery in 1962, moved the country very far in one direction, but there wasn't much theory behind the Kempe Center other than a false claim that there were millions of children being physically abused by their parents, which was a canard from day one, but it did a lot of harm. Goldstein, Freud, and Solnit stood for three things. As brilliant theorists, it's unbelievably sad to appreciate the degree to which their work was garbled, ignored, twisted, and ultimately used to erect a system that was almost the polar opposite of what they had begged for. Now, they stood for three particular things. One was to sharply limit governmental power to remove children. The second was to limit the time that children would remain in foster care once they were removed from their parents. And the third was don't give children lawyers. Of course, what happened, I shouldn't say of course, but how these great theorists were ignored almost to the point that the system their work helped build went in the opposite direction is an important story. Most importantly, the founders of this system in the 1970s completely disregarded their first principle. Instead of forbidding the removal of any child, except upon a showing of severe physical abuse, the founders of the modern system merely required a judge to declare that keeping a child at home would be, quote, contrary to the child's well-being. What that led to was a shocking growth of children being placed in foster care from 1975 to the end of the 1980s into the 1990s, having 500,000 children in foster care on any one day became a commonplace. But what the designers of the system also did was take seriously Goldstein's, I'll call it Goldstein's for the three of them, notion that once you've removed children, then measure time in a child sense and don't let them lag in foster care, and terminate parental rights and place children for adoption when they can't go home within a reasonable period of time, say a year and a half. Now, what would the system look like today had their vision be scrupulously enforced? And the short answer is nothing like this one. Yes, we would have placed children who were removed from their families on a tight timeline before destroying their legal bonds to their family of origin. But it's crucial to understand which children would have been in care under their formula. In rough numbers, we could say it would be less than 20% of today's foster care population. Precisely because the only children who would be subject to the unavoidable harm associated with being pulled from their family. And let's fully comprehend, these theorists were writing as members of the healthcare professionals, whose first principle is first do no harm. Every intervention, according to these theorists, involves harm. They begged and cajoled this new budding industry never to forget that. Indeed, to organize the entire system around it. How to do it? Draft laws that forbid removing children from their families except under extremely limited circumstances. No theorists before or since went as far as they did to strive to limit the circumstances for state officials to be empowered to take children into their care. Did they recommend these harsh limits because they didn't believe children deserved to be protected from harm? Of course not. They did so because they well understood, in precisely the way the current system ignores, the embedded harm that occurs each time a child is removed from their family. First do no harm was the singular call from these theorists. And what it meant for their theory is that anything they wrote about what should happen to children once they were removed was based on their understanding that the only children who would be in foster care were removed because they suffered a very high degree of harm when living with their families. The harm was so great that it warranted, even under these theorists' understanding, exposing children to the harm of the removal itself. So, as our foster care population hovered near 500,000 children for several decades, this meant something on the order of 400,000 children were removed from families each year since their work was published, who would never have been removed if their work had been taken seriously by the industry. Now, it's something on the order of 12 million children whose lives and whose families' lives have been very negatively impacted by the United States family regulation system in violation of their principles. And of these 12 million children, perhaps 1 or 2 million saw their families permanently destroyed under a regime that could not have happened if their work had been taken seriously. Now, back to the key point. They meant to design a system that would work in the best interests of children and families. They also had a third principle to their work, which was never to appoint a lawyer for a child until after the parents had been adjudicated as unfit. And I'm foolish enough to emphasize this point in our current history. Despite my understanding that the system has become so familiar with the idea that children deserve to be represented in court, that I can't help but be pushed aside by the majority as a kook. And so I want to align myself with these theorists to suggest that I'm in good company with other so-called kooks. And if I'm to remain faithful to principle, then it's important to re-argue this extremely important concept. No lawyers for children until after the parents have been adjudicated unfit would pay very high dividends for everyone in this system. Unless the children's bar is worried about losing its place in the system, there's a simple, elegant solution. In a world of extremely limited legal resources, a world in which a very tiny portion of the bar pays even the slightest interest in the family regulation field, there is a crisis need to create a multiple of the number of lawyers who work in this field on behalf of parents, fighting the civil rights battle that most Americans do not even recognize is being waged within its borders every day. All we need to do is change the role assigned to this huge cadre of legal professionals, skilled in the law, highly trained by the National Association of Counsel for Children, certified as experts, and participating in a scheme in which even the most casual observer would agree is characterized by a shocking shortage of well-qualified, well-paid lawyers to do the work. The solution is staring us in the face. Reorient the children's bar to become parents' lawyers. We have the budget for this already in place. We could instantly turn what is a widely shared agreement of a serious shortage of professionals into a surplus. Now, this, of course, was never Goldstein's consideration. His point, their point, the theorists, something I shared all my life, is that presumptively innocent parents do not lose their constitutional right to make decisions for their children merely when a state official files a paper in court alleging on information and belief that a child was neglected. Until there's an adjudication, these theorists explain, assigning their child a lawyer violated a parent's constitutional right protected by a long line of Supreme Court decisions. How did that one get lost? Well, it's a long story, but since I'm speaking at a Kempe Center function, it can't go without saying that Kempe's own Don Brass, who long revealed a negative view of parental rights, was the leading voice for giving children's lawyers, even while ignoring the sad truth that parents have far too rarely been provided with adequate legal representation throughout this history. You know, if we were just reimagining what we're doing, if we were starting over, if we were drawing the game plan for this system, think about what we drew. We created a legal regime that had a charging instrument filed by a government prosecutor designed to have a trial before a neutral magistrate. And the only other professional they wanted in the courtroom was the putative victim's lawyer. We ought to laugh at that. The system was rigged to have a prosecutor and the putative victim as the only lawyers in the room before a judge. That's the system that New York State implemented when I began practicing law in 1971. There were prosecutors in the court. There were children's lawyers. I was one of them because there was no other job. There were no such things as parents' lawyers. And so what were the children's lawyers' understanding of their role? What else do you do when you're representing a putative victim? Then protect them. And how do you best protect a person about whom one believes, of whom one believes is a victim? Well, you remove them from their family. So in the court in which I grew up as a baby lawyer, the prosecutor asked for the children's removal, and the children's lawyers asked for the children's removal. And I saw some cases where the prosecutor didn't ask for the children's removal, but the children's lawyers asked for the children's removal. And all the while, there's no parents bar. So then you take this to the Supreme Court of the United States and you say, Your Honors, we've got a serious problem here. Everyone in the courtroom is being represented by a lawyer except the only person who's incapable of defending themselves and is accused of wrongdoing. Surely that parent must be given a lawyer. And the Supreme Court, we're getting used to it in 2024 to read decisions from the court that shock us. But in 1981, we were shocked by a decision that said, no, parents don't have a constitutional right to representation. So what we see throughout the United States is a vastly underfinanced parent defense bar, a powerful example of how classism and racism leaves the politically powerless behind. It is inconceivable that politicians or judges in this country would stand even for a moment for a system that requires that parents with wealth would be forced to defend themselves or be given a lawyer with the high caseload, poor training, and astonishingly poor salary that is acceptable throughout this country today to do this work. The continued failure to address this problem is by itself proof of the embedded classism at the core of this system. Precisely because it impacts only the politically powerless, it fails to get the resources the politically powerful would demand for themselves. I don't mean to fight that fight just now, only to note how much worse this is when we are wasting so much legal talent by insisting upon a well-financed, commonly significantly better financed legal services delivery system for children. So give this a try for a decade. Go back, rewrite the laws and practices through the prescription of Goldstein, Freud, and Solnit. Stop assigning every child named in a petition, even before evidence is taken in court, a lawyer, and reassign the thousands of well-trained children's lawyers to represent the parents. Let's see where that leads us over the next decade. I've no doubt where it would. Significantly fewer children would be removed from their homes. Significantly fewer families would be destroyed. There would be better outcomes for families. And perhaps a quaint idea too, more justice. If only we had taken Goldstein, Freud, and Solnit to heart. Now, Kendall, I could keep talking and say a bit more about what we know about the great success of parent representation. Good. So I'll keep talking. I hope I haven't turned too many people off too much so far.
Please do. Go ahead.
But now let me tell you about what we know about excellent parent representation. So when I started practicing in New York City, as I said, before parents were represented, I worked in an office that was an astonishing place to work because we had social workers on our staff to represent children in court. And we were an interdisciplinary practice. And I was born into that practice. The visionary was a guy named Charlie Shinitsky, who the more I think about the work he did in his lifetime, the more impressed I am with his vision. And then over time, I got turned off by the fact that New York City didn't care about giving parents lawyers and rigged the system so that children entered foster care, not because they should have, but because their parents were outgunned. And I said, I have the gift of being an advocate. I'm going to try to re-establish Shinitsky's vision and create a parent defender bar that's interdisciplinary. And I lobbied for that for 15 years in New York City. And one day magically received what felt like a magical phone call that the city agreed finally to put out a request for proposal to create interdisciplinary legal representation in New York City. The first time ever, the lawyers representing parents wouldn't be solo practitioners coming to court with their own briefcase, but would be working as staff attorneys in an office with investigators, social workers. And what's so important about interdisciplinary representation? Well, it's that the real work happens out of court. Court is the place where judges read reports or hear reports. But who writes the report and what goes into the report is the real work in this field. And by the way, going back to the idea of children's lawyers, I'd love to see children's lawyers representing children who are state wards, but they don't need to be going to court every day. They need to be going to the institutions where their children are residing. They need to go to the case meetings where stories about children are being told. They need to correct those stories. They need to make sure that what goes into a report is accurate. And in the interdisciplinary legal representation that began in New York City in 2007, we paid more attention to out-of-court work. We attended every case planning conference. We argued over every service being put on the service plan to ensure that parents didn't need to do things that weren't necessary and needed to do things that were necessary. Because in my lifetime, I've seen hundreds of families permanently destroyed because a parent failed to comply with a service plan that wouldn't have helped her had she complied with it. And because that's how boxes get checked in this field. The question, would it have mattered that you completed the plan, never was asked. It was merely, did you complete the plan? Oh no, terminate rights. And what we did was transform practice. And then I was able to persuade the Casey Foundation to invest a considerable sum of money to do the most thorough research on legal representation that was ever done. And it was completed in 2019. And it compared, starting with 28,000 cases over 4 years, the outcome of cases with children, with families who, half of whom were represented by the new lawyer, the interdisciplinary lawyer, and half were represented by the solo practitioner. And, suffice it to say, we killed it. It showed that we avoided foster care in so many cases without any harm to the children, that quantifying the cost of foster care alone over a 4-year period would save New York City close to $40 million a year. In other words, we proved that without any increased risk in child safety, children were spending months and years in foster care needlessly for the sole reason that they weren't given the correct kind of lawyer. And a key factor in the success of interdisciplinary legal representation is the degree to which parents are supported out of court. Not only advocating for them at conferences, assisting them to enroll in court-ordered programs, otherwise attending to their need, but giving them the lift up, the support, the emotional concern of empathic professionals, careful attention to their well-being, the opportunity to believe somebody cares, somebody's there, I'm not alone, I'm not terrible. Most parents who go through this system feel alone and feel terrible and feel that this is a rigged game against them. And I won't even go into the question, are they right? Let's leave that for another day. Let me just say they're right to this limited extent at least. We know what kind of representation we should be giving parents throughout the United States. We know if we gave them that kind of representation, almost 50% more often, children would be returned home within the first year of care. We would sharply reduce the removal rate. We would dramatically increase the reuniting rate. And all of that would happen without any harm to the child's well-being. So we began in a system that was so bizarre in creating a system where you would have a prosecutor and a second prosecutor and no defender. I mean, talk about stacking the odds. Now we know what kind of lawyer not just parents deserve, children deserve. Children deserve to have their parents represented by the best lawyer in town. We know what the best lawyer in town looks like. We don't have enough resources in the legal community to provide it because we're wasting this extraordinary amount of legal resource in child representation. And what I'm here to ask you to do is fight for the idea of changing our understanding of how courts should look. Make these children's lawyers, parents' lawyers, make their commitment to be to defend the parents' right to raise them. Let the government make its best case for a contrary result. And what I'm here to tell you is far fewer children would be needlessly separated from their families. Far fewer families would be needlessly destroyed. And much of that could come from the simple device of making children's lawyers parents' lawyers. Thank you.
Thank you for that, Marty. And we're starting to get questions in. So let me encourage everybody, pop a question into the chat if you're on Zoom, or in the Q&A feature if you are on Attendee Hub. Marty, I've got a question here. Children deserve to have their parents well represented, this person is saying. Parents have a right to raise them. Who stands in the way of your vision, Marty?
Well, I work closely with the American Bar Association and the Center on the Children and the Law, and they fully embrace children's representation and parents' representation. And I'm sure if anybody from there is listening today, they wished I hadn't said as much as I've said. Who's standing in the way? The Children's Bar. We have a conference every 2 years. The first 2 days is the Children's Bar. The second 2 days is the Parents' Bar. They no longer say that, but people know when they go. The vibe in those two rooms is very different. In the Children's Bar room, the vibe is we're doing pretty good. We get good training. We get our certificate. We know how to represent children. In the parents' 2-day conference, the sky is falling. They're removing children needlessly. They're destroying families needlessly. Who's standing in the way? Well, I don't know any serious members of Congress or local government that's deeply committed to strong parental representation in our field, right? Who should be making this claim? Well, the National Association of Counsel for Children should be making this claim. I don't know if I would go so far. I don't want to make enemies today to say they're standing in the way. They're not noisy enough.
You've got comments coming in thanking you. Someone just said, really appreciate what you have shared. I'd like to invite you. You've talked a lot, and I would say a very compelling way, about the key decision-making about removal at the start of a case. Could you journey with us for a second to termination of parental rights? That is an area that, as you know, termination of parental rights is sometimes referred to as a civil death penalty. People are aware that termination of parental rights, whether or not it's exclusively American, is very much embedded in the American system. These are bad people, and not only should they not care for their kids, they should never have any contact or relationship with their kids. Is termination of parental rights a necessary part of this system? And if it is not, does it need to be replaced? Talk to us about termination of parental rights.
Many today characterize themselves as abolitionists who want us to, if they mean by that, no longer have a system that cares about children being raised in dangerous homes, right? I'm a child protectionist. I believe that a society should care about all vulnerable citizens. And I'm happy suggesting that children should be said to have the right to be protected from harm, whoever inflicts it upon them. That's why I'm a Goldstein, Freud, and Solnit advocate. I want to define the harm that warrants intervention so narrowly. So when we read headline stories and all media cover the gross examples of children being tied up for days in a refrigerator, people who do that shouldn't be permitted a second chance to raise those children. Unless you can make me conclude that what you were doing has an explanation and is now in the past, but that was their point, that if we limit the system to the cases where all reasonable people would say that's unacceptable, right? But now what we've done is open it up to parents engaging in behavior that's unacceptable, not to their children, to themselves. They're drinking too much. They're using dangerous substances too much. That's not a basis for removing children from families, least of all a basis for destroying families. We have shifted from the core focus of the Goldstein vision of protecting children from a form of gross harm that's unacceptable to judging behavior of people who happen to be parents. And those are two different questions.
Speaking of harm, our system, as you said, focuses on harm that comes to kids from family members, from parents. There's a question in the chat about harms that government may inflict, sometimes on whole populations, whether that's lead paint or contaminated water. Is this something that child welfare should care about? Harms that come from the government, is it something that the Children's Bar should care about?
Well, so I think the last time I spoke to the Kempe Center, the talk was called Child Welfare is Propaganda. And I made the point there that this whole system really is designed to shift the focus from how much government abuses children, to use the word abuse in the way that the child welfare system does, by deliberately exposing children to known harms that are life-altering, that result in early death, that are not only known, but that are preventable and that are imposed by the government. So we live in a dystopian, futuristic world that's real today. The people who claim to care most about children are the ones harming children the most. Of course, it's not that the child welfare professionals should be paying attention to that. It's that they created these child welfare professionals precisely so that they would avoid caring about that. We've defined child welfare exclusively as harms inflicted upon children at home. That's why it's a family regulation system. It's not a child welfare system. It never was it's a fake child welfare system.
Thank you, Marty Guggenheim. We are at time. I'd like to thank everyone who's been a part of this, and then again remind you there will be an opportunity with what we call a dialogue to continue this conversation. We invite all of you to join in that. And Marty, thank you for being a friend of children and their families. Thank you for your contributions to this field. And thank you for being with us today.
My pleasure. Thank you, Kendall.
Thank you all. Thank you all for being a part of this, and hope to see you at this coming dialogue. Thank you.